I had my eye on those Maryland and Rhode Island cases because they could have put assault weapon bans squarely in the Supreme Court's sights. Instead, the justices took a pass, leaving those state laws standing and setting the stage for an even bigger legal fight down the road. What's up, everyone? This is Ted from Line 45, and today I'm breaking down why the court sidestepped these cases, what it means for gun laws right now, and how it could shape the next wave of Second Amendment battles. Before I start, I would really appreciate it if you would push those buttons below, the subscribe button, the notification bell, all of them. This is not necessary, but those little clicks help a brother out. Plus, it pushes me to give you more valuable gun-related content on your screen. Now, buckle up, and let's get back to the video. When the court's the 2nd of June order list came out, I had my eyes on two cases in particular: Maryland's challenge to its 2013 Firearm Safety Act and Rhode Island's fight over its 10-round magazine cap. Both had the potential to put assault weapon and magazine bans squarely on the Supreme Court's plate. Instead, the justices denied review in each, leaving the Fourth Circuit's and First Circuit's rulings in place. That means Maryland's named model semi-auto rifle ban is still in force, and Rhode Island's magazine restriction still applies without interruption. It wasn't a merits decision, but it was enough to keep the status quo locked in for now. From my end, that's not just a headline. It's something I feel in real planning. If I'm headed to a match in Maryland, I'm double-checking rifle configurations against their list. In Rhode Island, I'm making sure every mag in my bag is pinned or manufactured for 10 rounds. That's the reality for anyone hauling gear across these state lines today. The court didn't write a full opinion, so there's no sweeping new guidance. But the denials fit a familiar pattern. Let the lower courts work more of these cases before stepping in. For folks following along, that means the laws in those two states are staying exactly as they are until another case earns a spot on the court's docket. And that's where the rest of this story starts to unfold. Even without a full opinion, the 2nd of June denials came with a few telling side notes. Justice Clarence Thomas wrote that Maryland's ban targets some of the most popular rifles in the country, and that the court should not keep avoiding the question of whether those firearms are protected under the Second Amendment. He was joined in sentiment by Justices Alito and Gorsuch, who also would have granted review in the Maryland case. Then there was Justice Brett Kavanaugh, who agreed with the denial for now but said flat out that the court should take up the issue sooner rather than later, once the right case comes along. For me, those separate writings are like hearing range commands before a stage starts: short, precise, and meant for anyone paying attention. 4 justices signaling interest is no small thing. That's enough to take note, especially when you consider how selective the court is about Second Amendment cases. I've read enough of these orders to know that this is as close as you get to a public reminder that the topic isn't being ignored. It's just not ready in their eyes. The fact that they made those comments in high-profile denials tells us the justices know the gun rights community, state legislatures, and lower courts are all watching. It's not movement in the way a granted case would be, but it's a clear marker on the road to the next big Second Amendment showdown. If you've spent time following firearms litigation, you know the Supreme Court doesn't grab every hot-button case the moment it's filed. They let issues percolate through the lower courts, building a stack of appellate opinions that test the same question from different angles. That's exactly what's happening with these assault weapon and magazine cases. In the last couple of years, we've seen the Fourth Circuit uphold Maryland's Firearm Safety Act, the First Circuit back Rhode Island's 10-round limit, the D.C. Circuit support Washington, D.C.'s magazine cap in Hansen v. District of Columbia, and the Ninth Circuit sustain California's similar law in Duncan v. Bonta. Each decision works off the same playbook, applying Bruin's history and tradition test, but the reasoning and emphasis vary by court. That's the raw material the Supreme Court eventually sifts through when it decides to step in. When I'm prepping to shoot out of state, that patchwork of rulings matters. It's not just whether a certain rifle or mag is legal, it's whether the local courts have signaled they're going to keep enforcing those laws while cases are still in motion. Percolation might frustrate folks who want a quick, definitive ruling, but it's how the court builds a record that can stand up over time. Until that process plays out, these appellate decisions are the rules we have to work under, and they're the reason Maryland and Rhode Island's laws are still shaping what gear I can pack today. Every one of these modern gun law challenges is running through the same legal filter the Supreme Court set down in New York State Rifle and Pistol Association versus Bruin back in 2022. That decision changed the way courts review Second Amendment cases. Now, instead of weighing public safety against individual rights, a law has to fit within the nation's historical tradition of firearm regulation. If the plain text of the Second Amendment covers the activity, like owning a certain type of firearm or magazine, the government has to prove a close historical analog exists for its restriction. You also can't talk about these cases without mentioning District of Columbia versus Heller from 2008. That's where the court recognized an individual right to keep and bear arms and discussed the idea of weapons in common use being protected. For rifle and magazine bans, that's a central point. AR-15 pattern rifles and standard capacity magazines are owned by millions. Whether those facts outweigh the historical analogs states bring forward is exactly where the legal fights get technical. From my own perspective as someone who shoots across different states, Bruin's historical test is why the arguments in these cases dig deep into 18th and 19th century laws, sometimes pulling in militia requirements or early weapon restrictions. That's not just academic work. It's the yardstick the courts are using to measure every modern firearms law, and how they interpret that history will decide whether these bans stand or fall when the Supreme Court finally takes one up. While the Supreme Court sits back, state and federal courts are still grinding through some big-ticket cases that could end up being the right vehicle for review. Illinois is probably the one I'm watching most closely. Their Protect Illinois Communities Act bans certain semi-automatic rifles and limits magazine capacity, and it's being challenged in multiple consolidated cases like Bevis versus Naperville and Herrera versus Raoul. The Seventh Circuit has already ruled at the preliminary injunction stage, siding with the state, but the merits phase is still active. Once that's done, you can bet a petition will head to Washington. Out west, Washington State Supreme Court upheld its own magazine limit earlier this year, framing magazines as components rather than protected arms under the Second Amendment. That's a key distinction, because it sidesteps part of the Heller and Bruin analysis challengers rely on. Meanwhile, California's Duncan v. Bonta decision in the Ninth Circuit upheld a similar 10-round cap, reinforcing that these laws are being sustained in multiple jurisdictions. For me, this patchwork means keeping tabs on more than just my home state's laws. If I'm headed to a training course or match in Illinois, Washington, or California, the court battles don't change the fact that the restrictions are enforced today. The litigation timeline isn't short, but each of these cases builds the record that could give the Supreme Court the clean split or legal framing it wants. Until then, these state-level decisions are the ones shaping what we can own and carry in those jurisdictions. Right now, the legal map for rifles and magazines looks like a patchwork quilt. 10 states and the District of Columbia enforce some version of an assault weapon ban, often defined by model names or a list of specific features. 14 states plus DC cap magazine capacity, with 10 rounds being the most common limit. Some of these laws have been on the books for decades. Others are only a year or two old, but all of them are being actively defended in court. The Supreme Court's choice not to step in this term leaves every one of these statutes intact for the time being. From a practical standpoint, that means traveling, shooters, hunters, and instructors need to be dialed into the local laws wherever they operate. I keep a set of 10-round mags in my range kit specifically for matches in restricted states, and I'll double-check a rifle's configuration against the host state's prohibited features list before it even leaves the safe. Grandfather clauses, registration requirements, and exemptions vary widely, so you can't assume what flies in one state will fly in the next. These laws also influence the firearms market itself. Manufacturers and dealers in restricted states often offer compliant versions of popular rifles with fixed stocks, non-threaded barrels, or factory-limited magazines. That's not a sign of the laws going away. It's the industry adapting to them. Until a higher court decision changes the playing field, this patchwork remains the operating reality, shaping how we buy, configure, and transport our firearms across the country. The Supreme Court's denials in the Maryland and Rhode Island cases didn't close the door. They just made it clear the justices are waiting for a case that hits all the right notes. In legal circles, that's finding the right vehicle, and it usually means a clean record from the lower courts, no messy procedural issues, and a clear conflict between circuits. Justice Kavanaugh even wrote that the court should take up the question sooner rather than later, which is as close as you'll get to a public heads-up from the bench. The cases in Illinois, Massachusetts, and California are strong candidates for that role. They're working through full merits decisions, backed by extensive factual records and multiple layers of appeals. If one of those circuits rules differently from the others, say, striking down a ban that other courts upheld, the Supreme Court will have exactly the split it often waits for before granting review. From where I'm sitting, that means keeping an eye on dockets, not headlines. These decisions move at the pace of litigation, not social media. In the meantime, the state-level laws remain in full effect, and compliance isn't optional if you want to stay on the right side of the law. When the court finally does take one of these cases, the decision will ripple far beyond the states involved. Until then, the strategy is patience, tracking the strongest cases, and making sure you're squared away with the laws where you live and where you shoot.